Good morning, and you're all very welcome. Excuse me, and thank you for joining us. My name is Anne Corr, and I am the Construction Market Advisor for Enterprise Ireland based in our London office. Our webinar today is Construction in the UK and Ireland post-Brexit. And if you have any questions throughout the webinar, please type them into the box that you'll see on the right-hand side of your screen, and we will cover them at the end. Also, a recording of this webinar will automatically be emailed to you within the next 48 hours and also available via our website. This webinar is a follow-up to a webinar that we held in October last year, where we discussed the legal ramifications of Brexit, particularly the legal impacts of a no-deal Brexit for the construction sector. Well, a deal was then agreed and the Trade and Cooperation Agreement came into effect on the 1st of January this year. So we're now 3 months in, and what does that mean? What does the Trade and Cooperation Agreement mean for labour and resourcing, goods, materials, standards and regulations, and opportunities and risks? And here to discuss these topics today, I'm now going to hand over to our panel of leading construction lawyers.
Thanks very much, Anne. Hello, everyone. My name is Jamie Ritchie, and I'm the first panelist. Today, I'm a partner with LK Shield Solicitors in Dublin, and I specialise in projects construction and procurement law. As Anne said, the last time EI ran this event was in October, and Brexit negotiations were ongoing. We explored what the situation might look like for Irish and UK contractors in the event of a no deal. Now that we have, thankfully, a deal, a TCA for the Trade and Cooperation Agreement, TCA for short. For my part today, I'm going to be looking at how new arrangements impact on the Irish construction industry going forward, as well as highlighting some key areas of focus for those within the sector.
Hi everybody, my name is Lisa Boyd. I'm a director in Cleaver Fulton Rankin Solicitors in Belfast. I head up our procurement team specialised in procurement and construction law. So I'm on the panel today to discuss the NI aspects of Brexit, which is essentially a hybrid of the Irish and GB positions with some quirks thrown in for good measures.
And good morning, I'm Dominic Jones. I'm a partner in the construction and planning business group at Blake Morgan. We're a team of 25 specialists spread across 5 offices, and we focus on all stages of construction, engineering, development and infrastructure projects. And I'm speaking today from the perspective of post-Brexit Great Britain, as opposed to the United Kingdom. And I'll need to be careful about when and how I use the terms UK and GB. And Lisa will keep me honest to that, because as we'll see, that they're not always interchangeable in this context. So before we dive into the detail, we're going to set the scene in terms of the legal framework. As Jamie and Anne have mentioned, this is a follow-up to a session back in October last year, and it just bears recalling briefly how much remained uncertain at that stage. Only 6 weeks before the end of the transition period, no deal Brexit, a very real possibility, and that remained a live concern until Christmas Eve. So at that point there was limited detail about how businesses operating across UK EU borders would need to operate in practice from the 1st of January this year. And we do have, you'll be glad to hear, some more clarity at this stage. But it's fair to say that there are practical issues that are still being ironed out, especially where there are grace periods in the rules coming into operation, which means that formal rules are not yet being enforced. So the transition period did end without further extension on the 30th of December last year, and the TCA that was signed on that day came into effect the following day. That's essentially a free trade agreement, which promises 100% tariff and quota free trade between the 2 trading blocs. And as you may have heard, it's a detailed document, runs to some 1,200 plus pages, including some fairly dense annexes and protocols. And most relevant to the construction sector are the rules on the trade in goods and services. Now, we're also going to touch on free movement of people and how that has now ended, meaning that subject to certain caveats, the immigration rules of the UK and the EU now apply to one another in the same way as they do to third countries. And we're looking at these key issues from the UK and Northern Irish construction sectors in each of those areas. So, and as Lisa said, we're going to touch on some considerations specific to the Ireland, Northern Ireland and GB relationship, such as common travel area and the Northern Ireland Protocol. And Lisa, I think you were going to touch on the NI Protocol.
Yep. So first of all, I thought, not to patronize anybody and not for any political reasons, I thought you've touched on it, I'd flag up the differences in the different jurisdictions. So the terminology UK and GB are used sort of interchangeably, but UK means GB plus Northern Ireland. GB excludes Northern Ireland, and phrases such as mainland UK don't have any legal definition. And I think we've all heard and seen in various documents references to mainland UK. It's just important when you're looking at your documentation or liaising with other parties that you make sure that you get the jurisdiction references correct whenever you're going through that. So what I was going to touch on very briefly is the fact that each jurisdiction has its own nuances, and that Northern Ireland is certainly unique in its position in terms of its hybrid status, as we'll talk about as we go through, and businesses based in GB and in Ireland may wish to seek to capitalise on this by having a base in Northern Ireland, and this could be achieved by incorporation and or having a physical presence in Northern Ireland. Now, specific advices should be sought to ascertain whether those benefits can be derived simply from having an incorporated company in Northern Ireland, or if a physical presence is required. Now, equally, companies may benefit from incorporating in Ireland and or GB, and the same considerations will apply equally across the jurisdictions. So in summary, some companies may find that they benefit from having a company set in each of the three jurisdictions. But as I say, advices should be sought before doing so from both a lawyer and an accountant. As such, multi-jurisdictional incorporation can bring many benefits, but also brings with it some risks. So I'm going to try and touch on the NI protocol and explain what it is and where we are at the minute. As most people will know, Northern Ireland was used as somewhat of a bargaining chip throughout the Brexit negotiations. It was finally agreed that there would be no checks on goods crossing the border between Northern Ireland and Ireland. So the aims of the protocol are to avoid a hard border between Northern Ireland and Ireland, maintain the integrity of the EU single market for goods, facilitate unfettered access for Northern Irish goods to GB market, and the inclusion of NI goods in free trade agreements between the UK and third countries. So the resulting effect has been that Northern Ireland has left the EU but remains in the EU single market, and has in effect created a new trade border between Northern Ireland and GB. Brexit and Northern Ireland and the NI protocol presents a unique challenge and a unique opportunity to every business in the UK and Ireland, and more particularly those businesses who trade across the three jurisdictions. So hopefully we'll be able to give you a bit more information as we go through. And I think Jamie's going to now just give an insight on the Irish perspective.
Yeah, it's more than a broad overview, just a broad overview more than anything else. I think you hit the nail on the head there, Lisa. The new arrangements from an Irish point of view, first and foremost, avoid a hard border on the island of Ireland. The TCA effectively ensures a single market for goods, and this is really of critical importance to the all-island economy, and in particular construction. In the last seminar in October, I think I highlighted the statistic from the CIF. It came from a report by the Construction Industry Federation in 2019 that its members believed that there would be cost increases of anywhere between 5 to 10% in construction in a no-deal Brexit scenario. Although now we have a deal in place, there are industry forecasts suggesting a cost increase of 2% this year, not least as a result of the new customs and regulatory regime. So the Irish construction industry has been acutely aware of the risks of Brexit for quite some time and has been taking action. This is in no small measure due to the excellent work of organisations such as our host today, Enterprise Ireland, That being said, there are significant challenges and hurdles to overcome, particularly from an East-West GB to Ireland trading perspective, and in terms of bringing UK suppliers and contractors up to speed on requirements as they relate to Ireland. This is very important because roughly 40% of all construction products used on Irish projects come or through the UK. And this is one area that I'm going to focus on today. So Anne, I think at this stage we can move on to the very first topic, which is labour and resourcing issues.
Thanks for that. Yeah, so Brexit does mean the end of free movement of people from the EU to the UK. However, it does exclude Ireland as there is the common travel area. And the restrictions on the freedom of movement will definitely be felt across the construction industry, because it's reported that there has been a loss of 46% of skilled EU workers that have now already left the UK. And the UK has and is already suffering from skilled shortages, and now that there's a points-based immigration system which might exclude roles such as general labourers, where does that leave the industry?
Yeah, thanks, Anne. So I think I'll kick off on this one. Free movement has ended. And as you say, Anne, that arises against the backdrop of structural issues around skills shortages and an ageing workforce that have been an issue for the UK construction sector for many years. And there are various causes of those issues, various initiatives intended to address them, including the Construction Leadership Council Skills Plan that was published just today. But one sticking plaster that has helped to plug some of the gaps has been the ability to rely on recruits from EU countries. And there are now real concerns that not enough has been done to avoid a fear of a cliff edge. So it is important for businesses to understand the rules that now apply to their workforce. And in brief summary, for EU workers moving to the UK for the first time after the 1st of January this year, the UK's points-based immigration system now applies to them in the same way as for any other non-UK worker. So they'll need a work visa and employer sponsorship. And that system involves minimum skills thresholds. So UK companies no longer have unlimited access to EU labourers to fill lower skilled roles. The skills thresholds that apply have been reduced though. So whereas before you were looking at construction managers and structural engineers, for instance, being eligible for skilled migration, that threshold has been lowered. You could now be extending sponsorship to building services consultants, foremen, carpenters, welders, electricians, those sorts of categories. The annual cap on skilled workers entering the UK has also been suspended for the time being, but worth noting that employers still need to have a sponsorship license and will need to demonstrate a genuine need for the role that they're sponsoring, although the requirement to show that no suitably qualified local worker could be found has been abolished, which is a good news for a lot of people. In relation to EU nationals who already lived in the UK on the 31st of December last year, there's a scheme called the EU Settlement Scheme, which applies. And that continues to accept applications until the middle of this year, till the 30th of June, 2021. And under that scheme, those who have lived in the UK for at least 5 years will be eligible for settled status, which is essentially a right of permanent residency. And those who have lived here for less than 5 years will be entitled to pre-settled status, which can then be converted to settled status once the 5-year residency requirement has been fulfilled. But with the focus on the Irish prism, it's important to note that Irish nationals don't need to apply for pre-settled or settled status via that EU settlement scheme. So the common travel area, which encompasses GB and the island of Ireland, predates the EU and was reaffirmed in a memorandum of understanding back in May 2019. And that enables Irish and British nationals to move seamlessly between the two countries. Lisa, I think you were going to add some thoughts on free movement and possibly on the common travel area as well.
Yeah, so I think you've obviously covered off very well sort of the Brexit ends the free movement of people to the UK, but I think it's just important to highlight that Northern Ireland remains part of the UK, and therefore the free movement of people between NI and GB remains unaffected. With regards to the common travel area, then obviously you've said that that predates the EU membership and therefore it's not dependent upon it. So Irish and British passport holders will be able to avail of the common travel area and won't need a permit in order to work in either side of the borders. Northern Ireland and Ireland have a long history of people crossing the border on a daily basis, and it's great that that can continue. Northern Ireland construction workers in particular have a long-standing history of working on construction projects in both Ireland and the UK. So I think in terms of the construction industry within Northern Ireland, it's very welcome that this has been able to be ironed out and that can continue in post-Brexit Northern Ireland. So Jamie, I think you were going to touch on the implications for the labour market.
Yeah, just very briefly to add in relation to the common travel area as well. I mean, the withdrawal agreement and the TCA expressly enshrine the right of the Republic of Ireland and the UK to make their own arrangements as it relates to the CTA. There's two, or is it the main legislation in Ireland is the sort of deals with this is the withdrawal of the UK from the EU Consequential Provisions Act 2020, which came into force in December 2020. It amends the Immigration Act in 2004, so that UK citizens do not come within the definition of non-nationals. And it also amends the Employment Permits Act 2006, such that UK citizens are included in an Irish company's EEA employee count for the purposes of making up the 50% employee count in order for employment permits to issue. So it's hoped that that will actually be of assistance in terms of cross-border partnerships for public procurement in the future. So broadly speaking, as Lisa and Dominic have outlined, the UK and the EU have committed to a level playing field for open and fair competition in relation to their labour markets. But as you say, what are the implications for the labour market if the CTA still exists? What are the implications for Ireland of the UK for ending free movement? Well, as we've heard, so many projects depend on construction workers and expertise from within the EU. There's undoubtedly a huge pool of talent and resource which the EU which Ireland can tap into, and this is going to go a long way to delivering some of Ireland's bigger infrastructure plans, such as Project Ireland 2040 and the Irish government's €116 billion plan to deliver major infrastructure over the next 20 years. And there's many thousands of jobs and apprenticeships that can be filled by skilled EU workers. So Ireland's expertise in construction is known globally, but we do have some shortages in resources in some key areas. So to a certain extent, the UK's loss is potentially Ireland's gain here. Dominic, I know I'm going to speak a little bit about mutual recognition of qualifications as well, but I think this is a good point for you potentially to come in on that.
Yeah, sure. Just briefly, I think this is a key point as well to note that until the end of the transition period, the EU directive on the mutual recognition of professional qualifications applied to the UK. That's now gone, which means that qualifications gained in an EU country now need to be recognised by the equivalent UK regulator, although qualifications recognised before the end of the transition do continue to be valid. So, I mean, as a consequence, I'm just going to give a bit of an anecdotal theme that we've seen discussed, which is that some professional services firms are considering some fundamental changes to their business models. So to take an example, the UK architectural practice that was behind the Pompidou Centre in Paris had previously serviced all its EU clients from London, but expressly due to Brexit has now decided to set up an office in Paris as a gateway to Europe. And although the expressed intention of the TCA was to avoid the need for companies to establish local presences to carry on doing business, the reality is that things are turning out to be a bit more complicated due to these potential issues with recognition of qualifications, also insurance arrangements, and less tangible things like the sense from EU clients that they're just more cautious about employing UK-based professionals. But Jamie, I'll hand on to you because I think there's some better news for Irish and UK construction professionals.
Yeah, I mean, this whole point goes hand in hand with the services issue as well, and how the TCA deals with this. But broadly speaking, you're right that the EU directive on professional qualifications no longer applies to the UK. The good news is it doesn't really affect you if you had a UK qualification recognised in Ireland before the 31st of December 2020, and that includes applications that were in the process of being recognised. So, for example, the Architects Registration Board in the UK has confirmed that architects with Irish qualifications that are already registered will continue to be registered. And similarly, there's been similar undertakings from the RIAI in Ireland with regards to architects with UK qualifications. So it's going to be an issue going forward for people who are going about really getting qualifications. But there's certainly, each regulated profession in Ireland is moving heaven and earth to try and ensure that mutual recognition is as painless as possible. And the Irish government has committed to working towards ensuring continued recognition of UK qualifications. So there will just be, I think, a bit of a bedding in period, particularly in the construction sector. Where it relates to services, I'm thinking more specifically in terms of your independent engineer, cost consultant, QS, or someone like that makes the regular trips over to Ireland, of which there are many. Where do you sit in terms of services? Is there that requirement that Dominic just talked about in terms of having to have a physical presence? Well, anecdotally, I mean, as lawyers, if a UK law firm under the current terms of the new TCA wanted to provide advice in Ireland, they have to have a commercial presence in Ireland, and that's something that requires them in order to be able to practice here. So that's set out in an express reservation in the TCA. The good news is that for construction, this is dealt with under reservation number 8. Access is described as, quote, unbound. Now, there are some sectors which will require an economic needs test to be carried out. This includes some telecoms related, railroad, transport maintenance related services. But by and large, access is unbound, which is really good news for construction companies and construction professionals looking to get into the Irish market. I mean, the TCA does not go much beyond preserving the levels of access that were previously enjoyed by businesses. And as I say, it's sort of described as a Canada-style arrangement, but it is good news for construction. Lisa and Dominic, were you going to say something about the consequences then of businesses operating in the UK?
Yeah. So Dominic's already touched on this briefly, and I was just going to flag up really that it's really important that all businesses seek to identify the workers in the business from EU countries and across the border, and just to observe the time limits. So workers in Northern Ireland from EU countries have until the 30th of June 2021 to apply for settled or pre-settled status, which should allow them to remain working in Northern Ireland. And as Dominic said earlier, after this period, workers from the EU or elsewhere will be subject to that points-based immigration system. And unfortunately, it is designed to facilitate the entry of skilled workers, and they're heavily geared towards how much an individual can earn or contribute. So it makes it difficult for those low-paid vacancies, and I think that's where Ireland probably has the upper hand on this one. Maybe just pass over to Dominic to see if you have anything more you want to add on that.
I mean, just to echo that, I think it's about being prepared and acting early, and these grace periods will come to an end quicker than you think. So yeah, it's that preparedness, making sure the applications are in as soon as possible, checking professional accreditations for people who want to carry on operating or move to the UK to operate as a regulated professional. And on the skilled immigration point, the budget announcement last week promised some changes to what's a fairly complicated area of immigration policy, intended to make it easier to use. And there's a promised roadmap which is due to be published in the summer, and then an elite points-based visa to be introduced by March 2022. So some spaces to watch. But I think that wraps up the section. So Anne, over to you to introduce the next one.
Yes, thanks. We're going to talk about goods and materials. So under the UK-EU Trade and Cooperation Agreement, most traders who move goods between the UK and the EU will not have to pay tariffs, but will have to meet relevant rules of origins for the products and make declarations. Despite the removal of import tariffs, it seems the price of goods moving across the border has increased, and this is due to additional border checks and increased administrative work. So say, for example, if you're moving construction materials from Ireland to the UK, it should be a seamless task. However, if that same company brings back goods from the UK to Ireland, there are border delays and it's not a seamless task. Is it the case that it'll take some time to settle down as construction grapples with a whole new host of rules and regulations, or is this going to be expected going forward?
I think I can take that one. And to start with, I think it's a mixture of both, really. It is going to take time for the processes to bed in. Goods imported into Ireland from GB obviously are subject to custom processes now. The revenue commissioners in Ireland really placed a great emphasis in ensuring that businesses got what was described as an economic operators registration identification number, an EORI. Once obtained, the number is a common reference for interacting with customs authorities across the EU and the member states. As of September last year, take-up was really successful and continues to be so. But as of September last year, there was more than 67,000 businesses that had registered for an EORI in Ireland. You'll need an EORI if your business will be making customs declarations or getting customs decisions in Ireland. So, you know, a lot of the hold-up has been around these sort of issues. If you're a UK company with operations in Ireland, it's incumbent on you to investigate this process and get registered as soon as possible. You can apply for an EORI through the Revenue's website. In reality, what we're seeing on the ground is that once you've got your EORI, much of the customs work is being outsourced to third-party providers, and you should be taking tax advice on those issues in any event. Dominic, Lisa, I don't know if you have any views on the goods and materials section.
I was just going to say that in relation to the EORI, if you're a GB-based importer or exporter, you should check that you have an EORI number that starts with GB. And you may also need one beginning with XI if you move goods to or from Northern Ireland. The process in GB was intended to be that HMRC would issue these GB prefix EORI numbers to all businesses that it expected were going to need one during the course of 2019. But I think it's been commented on that process missed out about 100,000 companies that are not VAT registered. So as Jamie says, if you are involved in trade, I guess it's just a point of checking that you've got one, and if not, applying for one at this stage.
Yeah, I was just going to cover the position then in Northern Ireland. So goods and materials moving strictly between Northern Ireland and Ireland or the EU don't require any declarations. If you're bringing goods into Northern Ireland from GB, there are two categories: whether they're at risk of leaving the UK or not at risk, goods at risk of entering the EU single market. So goods that are not at risk of leaving the UK are tariff-free. Goods that are at risk of entering the EU single market will be subject to tariffs. So what you need to do is to look to see whether or not you are entitled to a preferential duty rate under the TCA, whether or not you can be authorised as not being at risk under the UK trader scheme, and thirdly, whether or not you can claim a waiver up to specified limits. The Trader Support Scheme, it's helping businesses navigate the changes for moving goods between NI and GB. And even if you're not currently in that position, it might be worth registering for it. There's lots of helpful information that you can get from that. And the Trader Support Scheme will provide that authorisation for those goods that are not at risk. Goods that are going from Northern Ireland to GB currently move freely, provided that they're not at risk of leaving the UK. Goods into Northern Ireland from outside the UK and the EU are subject to UK duty if they're not at risk to move to the EU. So you can see that there's quite a few different regimes that are at play. It's important that you seek out and ascertain which regime that you are subject to, and as both Jamie and Dominic has said, make sure that you've got the requisite identification numbers and things in place. So I think then Dominic and Jamie, you were just going to give a few examples of how you've seen this play out in practice.
Yeah, I mean, I think the point really is that despite this expectation of frictionless trade, there are concerns and some examples of delays at borders. I'm sure many people listening to the webinar have experienced this, that are arising because of the additional red tape that Jamie and Anne mentioned at the start of the section. So it's delays, and so often that means additional admin and price increase as well. So just from press reports, there are stories of the prices for roofing and timber products rising by around 20%, and steel price hikes in the order of 40%. Although steel shortages are a bit of a perennial issue, these current problems do seem, at least in part, to arise due to things like a shortage of shipping containers. Certain carriers are seemingly reluctant to take bookings for shippings to the UK because of fears of congestion when they arrive at a UK port, and particularly that's the case when there's healthy demand elsewhere as economic activity is rebounding globally. So what we're seeing is that some projects are having to reassess their approach to programming, in some cases considering moving away from just-in-time deliveries for certain items with unpredictable lead times. And the other thing I was going to mention was that last week it was reported that the new Brexit minister, Lord Frost, is considering relaxing some customs checks due to fears of food security, food scarcity. So this is a bit of crystal ball gazing, but it's not impossible that a similar approach might be taken if border delays threaten to impact the UK government's ambition for the construction sector to lead the post-COVID recovery. So yeah, it's not legal analysis, but that's some of what we're seeing in the market. Jamie, anything to add from your perspective?
Yeah, no, all I was going to mention was that obviously there are a huge amount of contractors and subcontractors that move backwards and forwards between GB and Ireland on the ferry. I attended a talk last week which referenced the subcontractor that comes over in a van a couple of times a month to work on projects. What are the issues for them in regards to their plants, machinery and tools? Well, the reality is, under the new arrangements coming into Ireland from GB, in order to avoid going through customs processes, you're going to have to complete what's known as an ATA Carney, which is a form which effectively allows goods to be brought in temporarily into Ireland or into the EU for specific purposes. It's an additional layer of complexity for the industry, and there are other longer-term solutions. I know that there's a lot of big GB contractors who have looked at and incorporated in Ireland to sort of get around this issue. Who knows, it may also have a positive effect on the plant hire sector in Ireland. Just really sort of remains to be seen, and time will tell. I was going to say as well, there's just a point where we really saw this issue of goods crystallizing early doors as construction lawyers was contractually. we saw the introduction of Brexit clauses. I certainly saw them as early as 2018 when I was dealing with funders on projects and negotiating construction documents, and there were concerns over delays at that early stage. Brexit clauses really, they've become more refined over time. They operate downstream, so an employer will tend to transfer the risk for construction delays and cost increases in materials and circumstances arising as a result of Brexit. It's therefore incumbent on you, if you are a main contractor and you're sort of carrying the can for potential delays, that you, to the extent that you can, try and back-to-back that risk in your subcontracts to avoid yourself getting unnecessarily exposed to any risk. Dominic, were you going to say something, I think, about introducing rules of origin in the context of the TCA?
Yes. So rules of origin is a concept that appears, it's common in all free trade agreements, and the essence of it is that as a corollary of eliminating customs duties in a free trade agreement, that preferential tariff treatment only applies to goods that originate in the participant trading blocks. Otherwise, the arrangement has the potential to distort competition. So what that means is that businesses seeking to move goods between the UK and the EU, if those goods would normally attract a customs duty, either under the UK global tariff or the EU common customs tariff, they'll need now to determine whether those products meet the rules of origin requirements in the TCA, and so are subject to the preferential tariff treatment. Exporters will need to classify their goods, establish the origin rule that's applicable to the particular good under the TCA, and then develop origin determination, calculation, certification, and record-keeping processes. Importers will need to check that the exporting suppliers understand the rules and provide evidence to support the origin qualifications of their products. They'll need to understand how to claim the preference at imports and then instruct customs brokers accordingly and keep records for when the auditors come knocking. Now, these are detailed rules, and there are extensive annexes around rules on tolerances where products are manufactured in the UK or the EU but comprise components from third countries. So, for instance, the originating status will not be lost if the non-originating material carries a value below 10% of the ex-works price of a product. And there are various other thresholds of that nature. There are also complications for supply chain arrangements, which are introduced by rules on processing. Now, those rules set out what does and what does not amount to sufficient production to enable a product to acquire and retain originating status in one of the participant blocks. And I think maybe the best way to explain what that means is by taking the case study of the Marks and Spencer's Percy Pig sweets. So those are manufactured in Germany, then shipped to the UK. They're stored here and then exported onto Ireland for sale by M&S there. Now, at that point, even though the goods started off in Germany in the EU and are ending up in the EU, they're effectively being exported back to the EU from GB. And because what has happened to them in GB is just storage, and that doesn't amount to sufficient production for the purposes of these rules, those sweets don't originate in the UK and may attract a customs duty when they're shipped onwards. So those sorts of concerns mean that suppliers and buyers need to look at their supply chain arrangements and consider whether the routes they're using, their processing arrangements, their warehousing options can be better aligned with these new trade rules. And the position is complicated by the fact that the rules and the tariffs are product specific. So there's some specific analysis to be done, and I believe that there are cases where suppliers are just choosing to pay the tariff rather than go through the rigmarole of putting in place the administrative processes to demonstrate origination, even if they might be entitled to benefit from the free trade arrangements. So potential minefield, some of it very straightforward, but it's as soon as you've got materials comprising a number of different components that things get complicated, components coming from different sources. Jamie, I think you had something on VAT.
Yeah, just to quickly add on the rules of origin point first. It's interesting what you say, Dominic. Certainly advice that has come out of the Irish government in recent times regarding the UK origin goods is that businesses should be claiming 0% on UK origin goods that meet the origin test, that they know meet the origin test, and that's usually captured on a statement of origin, which may appear on an invoice or other sales documents. So they go through the process, but they don't necessarily attract the liability. VAT is just worth touching on. Irish import VAT is typically due at the time the goods are imported into Ireland. Businesses can alternatively look at setting up the option of a deferred payment account with the Irish Revenue to help alleviate payments associated with import VAT. The terms of the Northern Ireland Protocol, as far as I'm aware, require Northern Ireland maintains alignment with EU VAT rules for goods, but not for services. And I think at that point, it's probably a nice segue into standards and regulations.
Okay, thank you very much. So yeah, standards and regulations, this is quite a complex sort of hangover from Brexit. I held a webinar in February this year to cover the UK Conformity Assessment, Mark UKCA, which came into effect on the 1st of January this year. It's quite complex and it raised numerous questions from our client companies. And the UKCA mark covers most products, but most especially construction products. And the advice from the panel on that webinar was don't wait until the end of the year, prepare now in capital letters. Another new regulation that is going to be introduced in the UK is the Building Safety Bill. And this bill was brought in following the Grenfell fire, and it's going to place new and enhanced regulatory regimes for building safety and for construction products. Again, would the advice be for construction to start implementing new practices now and not wait for legislation to catch up? And then finally, the UK is to have its own standards for building products, materials and machinery, or will the UK continue to observe EU regulations? So over to you guys to try and unravel that.
I'm happy to start, Anne, and then pass on to Dominic and Lisa. Really, the principal legislation in Ireland is the European Union Construction Products Regulations 2013, which transposes the EU CPR directive. And CPR requires products to have the declaration of performance and the infamous CE marking that we're all talking about. As we know, third-party bodies called notified bodies assess products and provide certificates of conformity. Crucially, notified bodies must be registered in an EU country. UK notified bodies lost their status after Brexit, so any products previously certified with the UK body would then need to be recertified with an EU notified body. If that's not done, there's questions over whether the materials can be lawfully used on Irish products. I see, and it's probably worth dealing with it now under this section, there is a question there just regarding whether self-certification is enough to comply with CE marking. At the moment, it really depends. You should be taking your lead from the national accreditation body for Ireland and the National Standards Authority, which is the National Standards Certification Authority of CE marking in Ireland. They will be able to provide detailed guidance on these specific issues. Dominic, I don't know if you have anything to add.
I mean, just that, as you say, the EU construction product regulation no longer applies in the UK, so we've got a new regime, and that new regulation applies in England, Wales and Scotland, while for Northern Ireland the position will continue to match EU requirements. And the intention really is to avoid disruption to the circulation of construction products as far as possible. So all day one UK designated standards are identical to the harmonised European standards. So there's no change in certification required for products that were on the market at the end of the transition period. But going forwards, new GB standards will be set by statutory instruments, and the conformity assessment activity for UK designated standards will be undertaken by UK approved bodies. So notified bodies, UK based, previously known as notified bodies, are now approved bodies. And the new UK conformity assessment, or UK CA mark, has come into effect for products placed on the market in GB, and there's a UK NI indication to be used with the CE mark in Northern Ireland. There's a transition period until the end of this year, during which the CE mark will continue to be used, provided that the relevant standards remain aligned during that period. But as Anne indicated, well-advised businesses are taking steps now to make sure that they're prepared to use the relevant markings in good time. And it is a specialist area of regulation. So that excellent webinar that Anne mentioned, I do commend that to you. I think they spent an hour or so, over an hour, talking about this topic alone. So there's a lot to get through, and if you're grappling with these issues, that's a good starting point. Now, it's worth noting that while a lot of these technical issues will be for importers to comply with, it's also important for those who certify those who specify and use construction products to understand these requirements, so they can ensure they're using safe materials, but also so they know that they know what's involved in complying with a contractual provision on deleterious materials, for instance, which will often reference the construction products regulation. And a couple of final thoughts. First, although we're starting off with this alignment between UK and EU standards and an intention to maintain consistency, there is a chance of divergence in some areas as new standards are introduced or there are updates, so something to look out for. And there's no mutual recognition, as you've said, Jamie, between standards and testing. So in the UK, it's left to the individual approved bodies to decide whether or not to accept EU-issued test type reports to enable UK CA marking, or whether retesting is going to be required. Whilst on the flip side, I think you've said from the EU perspective, retesting is going to be needed if it's been done by a UK approved body. Yes, I'm not sure whether Lisa has anything to add from her perspective.
Yeah, I was just going to touch briefly on the UK NI mark. So as long as the NI protocols enforce, NI will align with the EU rules relating to placing on manufactured goods on the market. Conformity markings will still be used. So the UK NI New Conformity Marking is for products that are placed on the market in Northern Ireland, which have undergone the conformity assessment by a UK-based body, and it's never used on its own. So just to give you an idea of products that are placed on the market in Northern Ireland and what the markings will be. So if you're placing goods on the market in Northern Ireland, the CE mark will be continued to be used if you're using the EU conformity assessment body, but it will be CE and UK NI if it's a UK body making that assessment. If you're moving goods from Northern Ireland to GB, there is unfettered access, as we've talked about, to the whole of the UK market without additional approvals. And again, the CE marking will be used if it's an EU assessment body, and the CE and UK NI markings will be used if you're using the UK assessment body. If the goods are being placed on the EU marking, only the CE marking will be used on its own, and the UK NI marking will not be recognised in the EU. So that's just to give you a flavour of the different options that we have in NI. And I think maybe you were going to touch then on the building safety bill, Dominic.
Yes, yeah, and tee that one up. And it's not really a Brexit related issue, this, but I mention it because it's relevant to anyone who's going to be involved in residential construction in the UK post-Brexit. I say not Brexit related, but obviously nothing is unaffected by that B word. And there's a good chance that we would have been a good bit further along in implementing the recommendations of the Hackett review if there'd been a bit more parliamentary time available in recent years. But in short, following the Grenfell Tower disaster in June 2017, the UK is now in the process of what the government is calling its biggest overhaul of building safety for 40 years. So we've had this building safety bill published in July of last year, alongside a number of more immediate initiatives to ban the use of combustible materials in external wall build-ups and to assist with funding of remedial works. The initial focus of the bill is on in-scope higher risk buildings, which are defined as multi-occupied high-rise buildings of over 18 metres or 6 stories in height, whichever comes first. But that scope may be extended to include other building types such as schools, hospitals, care homes in due course. The bill provides for a new building safety regulator, which will sit within the Health and Safety Executive. And the government has already taken steps to set that up. Last month, it appointed Peter Baker as the first Chief Inspector of Buildings to head up that regulator. And it's going to have wide-ranging powers and functions, including taking over the building control regime for high-risk buildings, enforcing sanctions for non-compliance, and improving competence across the industry. The bill also gives legislative footing for the New Homes Ombudsman, which is intended to develop a scheme around standards of workmanship that all developers of new homes will need to join, and it will then serve as a system of redress against developers who break those rules. The Hackett recommendations around accountability and the golden thread of key information are also implemented, and that's by placing obligations on duty holders at key stages of the process. This builds on the duty holder approach taken in the CDM regulations, health and safety. So in short, client and principal designer will be responsible during the design phase, the principal contractor during the construction phase, and then an accountable person, so usually the owner, at the occupation stage, including by having to appoint a building safety manager. And the system is divided into 3 gateways, with information being assessed at each stage by the regulator. Gateway 1 is the planning application stage. Gateway 2 is initial building control, and that includes a hard stop so that construction can't begin until the regulator is satisfied that design meets the safety requirements. And Gateway 3 is then at the completion of final certificate stage, when all prescribed information must be handed over to the accountable person and the regulator. So I counter through it, but from a contractual point of view, I suspect we're going to see that practical completion will often be made conditional upon Gateway 3 information being delivered. And for those working on higher risk buildings, it's important to understand the obligations of the relevant duty holders and ensure that you can demonstrate compliance through appropriate training and accreditation. Much of this detail is yet to be developed by way of statutory instruments, and there's a fairly extended scrutiny and consultation period anticipated. But the idea is that the Act will come into force over the course of the coming year. We'll also need to monitor closely how the insurance industry responds to the new regime. And as I say, over the course of this year, there's likely to be some debate around some of the perceived areas that need enhancement or perceived gaps in the bill, such as how liability for defects will be addressed, and how the various levies that are going to be used to fund the new arrangements are actually going to be applied. So that's what I had on the building safety bill. Jamie, were you going to touch on some issues around data protection and the construction industry register?
Yeah, just hearing you speak there, Dominic. I think actually originally we were going to deal with data protection first and then go on to SIRI, but I think the construction industry register is a nice one to follow on from your discussion on the UK safety bill. Much has been made of the construction industry register in Ireland. This is a voluntary register supported by government, which consists of a list of effectively competent builders. As part of the process for applying, applicants need to demonstrate minimum experience and competencies, understanding of Irish construction standards, as well as minimal technical competencies. The reason I bring it up is, again, it's not really a Brexit point, but momentum remains to put this register on a statutory and mandatory footing. And there certainly have been noises coming out of government about that. So construction companies, UK construction companies doing business in Ireland or looking to Ireland in the future would be well advised to explore the process of getting registered with SIRI as soon as possible. The other area which I wanted to focus on just under this standards and regulations heading, it's a bit out on its own, but it is a very, very important issue, is data protection. Very relevant to cross-border work, services sector, but really to anyone that's transferring data between Ireland and the UK. The DCA provided for a specified period of up to 6 months where there was not really any need for any additional safeguards. It was intended, and certainly is intended during this time, that there'll be an adequacy decision on equivalence of data during that period. Now, on the 19th of February, there was a very positive draft decision that was released by the European Commission in relation to adequacy. That being said, this is only the first stage in the process. I spoke to our data protection partner just a few weeks ago on this, and very at pains to stress that if you are a company involved in transferring data between Ireland and the UK, you shouldn't take it for granted that there might be an adequacy decision in the next couple of months before the period ends, and you should be taking ongoing advice from data protection lawyers, irrespective of the positive signs that adequacy might be granted in the future. I think that closes off standards and regulations, and if we want to move on to the final section, which is opportunities and risks.
Thank you. So yeah, opportunities. Has Brexit created opportunities? So despite the current uncertainties, there are signs that fundamental change is happening within the industry. There's a shift towards off-site manufacturing, and there's the increased use of digital technologies and a growing urgency to address the climate change. There's also been a rise in the use of off-site, especially within the public sector, and then maybe as part of the government's drive to build back better, greener and faster. We have a lot of client companies who deliver off-site solutions in the UK, and they've seen the demand increase in off-site. However, is this increase in opportunity created by Brexit, or is it as a result of COVID?
Thanks, Anne. Well, I'm going to kick off this section and firstly touch on public procurement regulations. So in the UK, post-Brexit, there has been a consultation on how the public procurement regulations will look going forward. The consultation closed yesterday, and the draft bill, etc., will follow later in the year, and new regulations are proposed to be implemented at the early stage of 2022. Obviously, moving away from the EU regime will allow the UK to implement different rules with regards to public procurement, but there are other treaties that are incorporated within the EU regime which will still have to be followed. So there will be some themes that will be familiar from the old regime. Currently in the UK, contracts can be found on the Contracts Finder, so moving away from the OG systems. In Northern Ireland, contracts can be located on a number of sites, eTenders NI, local council websites, CPD have a procurement portal as well, and each of the COPs, such as the Housing Executive, Education Authority, they also publish their pipeline for procurement opportunities. So as I said, the Green Paper consultation has closed, but just to touch on some of the considerations within that paper and the changes that you might see in the UK with regards to public procurement. So firstly, there's been some amendments proposed to codify the case law that has come into being since the regulations came into law in 2015. But in addition, there has been a number of different processes. So one of the first processes, which comes post-Brexit, but also out of the COVID pandemic, is a new crisis process to allow emergency plans and procurements to be put into place. Instead of having a number of different procurement regulations for concessions, public sector utilities, there's a proposal that there will just be one set of regulations which will be useful. There's going to be different procurement procedures. There may be changes to the processes that you're used to seeing. A cap on damages in procurement litigation, procurement tribunals to deal with lower value procurement disputes, and a centralisation of items such as disputes and debarments. So public authorities will be able to go on to those lists and see who has issued proceedings previously and who are debarred for various reasons from being accepted on to contracts. So that's really just to give a flavour of what may come. Obviously, the consultation has closed, and we're yet to see what the bill is going to look like. So if you're involved in public sector procurement in the UK, keep your eye out for those coming. And I think that Jamie is going to have a quick word on that and then move on to Project Ireland.
Yes, thanks, Lisa. I mean, this is an area that Lisa and I have looked at closely and worked on together for a while now, both in terms of in terms of public procurement on a cross-border level. From an Irish point of view, the situation in regards to procurement is largely preserved. The UK's accession to the GPA makes life a lot easier under the Regulation 25 of the Award of Public Contracts regulations. Contracting authorities in Ireland are bound to treat economic operators covered by the GPA no less favourably than the treatment afforded to economic operators in the EU. So this is very positive. You have to remember though that tenderers, regardless of whether you're coming from the UK or Northern Ireland or otherwise into Ireland for public contracts, they're going to face the same range of commercial challenges as any other company coming to do business in Ireland. So that this covers all the ranges of topics that we've spoken about here today. But it is very positive and it's very relevant to the public Project Ireland 2040 because the lion's share of those projects brought about by this initiative will be public contracts. Notwithstanding the pandemic and various other challenges, there's going to be a seismic rise in activity, construction activity in Ireland over the next few years. Broadly speaking, the value of the industry in Ireland was sitting at about 27 billion pre-pandemic. And depending on which reports you read, this went down to around 17.9 billion in 2020 as a result of the pandemic. But it's going to level off at around 23 billion this year. The Department of Finance still estimates a significant rise, and certainly pre-pandemic, they were talking around 41 billion within the next few years. So there's huge opportunity there. The private sector also has its role to play in these projects. there's significant growth in the data center market. There's going to be around €4.5 billion of investment in the data center market by 2025. We obviously have a housing shortage, so there's a real focus there on development, major infrastructure plans in terms of transport as well, such as the Project Metro, which is the link between Dublin Airport and Dublin City Centre. That's one that we're increasingly getting asked about by potential tenderers. And then obviously FDI, foreign direct investment, is really a mainstay as well of the UK, or sorry, the Irish construction sector for large commercial projects. So there's an awful lot to be positive about coming out of the pandemic. Dominic, I don't know if you were going to say something about the UK infrastructure plans.
Yeah, thank you. I'm very conscious of time, so I'll canter through a few thoughts I had. Just on procurement changes, just wanted to flag that we've got a new Construction Playbook that was introduced in December last year, which sets out essentially what it's a compact between the government and industry, and it sets out what is expected from industry, bringing together various themes around the importance of social value and net zero carbon, modern methods of construction, prompt payment, quality management. Those principles, which have been a bit ad hoc and dispersed, are brought together in this playbook. And I think it's going to be interesting to see how some of those new approaches to procurement, with focus on outcomes and value, rather than just pure time and cost, will help to address some of the problems that we so often see with mega projects that are measured solely against budget and programme, and get criticised for failing to hit those measures, with less understanding of the intended outcomes and benefits. So in terms of UK infrastructure horizon scanning, there's been a lot of rhetoric around the ambition for the construction sector to lead the economic recovery post-COVID and post-Brexit. And the budget that was announced last week put a bit of flesh on those bones of the Build Back Better and the Levelling Up agenda slogans. A key development is the National Infrastructure Bank, which is the UK's post-Brexit answer to fill the gap that's left by the European Investment Bank. The NIB is opening up in Leeds in the spring with £12 billion of equity and debt financing available, and 10 billion for use as guarantees. And the target is to support £40 billion worth of private and public sector infrastructure projects as a driving force behind the green building revolution, focusing on clean energy, transport, digital, water and waste projects. Budget also announced the location of the 8 free ports in England, and there are discussions about free ports ongoing in Wales, Scotland and Northern Ireland. So free ports, very briefly, will offer generous tax reliefs, simplified customs procedures, wider government support as well, and they're intended to stimulate investment, trade and job creation. Some interesting developments in relation to R&D support, creation of a task force on modern methods of construction, and training schemes available for SMEs. So lots of ambition, I think, is the headline, and a real hope that this ambition will be translated into success. But I think the initial view is that will depend on just how quickly money starts to flow. And of course, that, as ever, needs to be balanced against the need to target resources appropriately. For instance, in light of, if you're talking about a big transport project, assessments having to be made about the need for transport, how that's going to be used in the post-COVID world. So conscious that's a very brief canter through, and there was one specific project that I think, Lisa, you were going to touch on to round us up.
Yeah, well, a lot of what you've said, Dominic, are UK-wide projects, so that will include Northern Ireland, and no doubt plans will be developed by our executive to spend our way out of the pandemic as the immunisation programme continues. It's you mentioned free ports as well, and it's expected that Northern Ireland will announce its own free port policy, but the model will probably be adapted from what you're using in England. And as you say, I think that the only way that we could end this talk was to mention Boris's borough, or the bridge that maybe is being mentioned in the news quite frequently. I heard it yesterday again, so I thought it would be remiss not to mention the elephant in the room. And who knows, in years to come, we may be talking about the project, whether it's below or under sea level. So with that, I'll pass back to Anne to round up.
Thank you very much. Yeah, it is a bit of an elephant in the room, isn't it? So we do have some questions that have come in. We've got a couple. I'm going to run very quickly through it because I know everyone's probably wanting to rush out for their lunch. So one question is, if you have a company in Ireland as well as the UK and you send materials to Ireland for testing in your Irish office, will you need to pay duty?
I'm happy to pick that one up, Anne. There is a temporary process for admission of goods for examination, analysis or test purposes, and the best way to explore that is if you go onto the Revenue's website. There is an entire page dedicated to this precise scenario, and it can explain how you go about doing it and how you avoid going about paying customs duty.
Okay, thank you. Another one is, since Brexit, we have issues ordering in parts from the UK. We're looking to source them. We're looking to source the items in other EU countries as a solution, but will this continue to be an issue for Irish construction businesses?
Again, Anne, I think that's probably one for me. It really is a case of how long the new processes will take to bed in. My own personal view is that there is going to be an element of Irish companies having to reorientate their supply chains towards Europe. That is what I expect will happen over the next coming months and years.
Okay.
Sorry,
go ahead.
I was just going to add a thought, which is, I guess it will depend to an extent on what the issues are. The intention of the TCA is to avoid disruptions, like what this questioner is experiencing, but there are complications that are being worked through, and I guess if the issue arises because of the rules of origin or the processing that we talked about, meaning that duties are applicable, then there might be alternative supply routes that can be considered. But if these difficulties arise just because of extra administrative charges, it might be that those are things that have to be lived with, and for those particular materials, alternative sources are the only way forwards to keep to the cost requirements. So I think it's, as Jamie says, it's one of those ones we'll have to wait and see how it all plays out.
Yeah.
Okay. So time for two more questions. If we miss a delivery due to Brexit customs delay, where do we stand contractually?
This really goes back to the point I made about Brexit clauses, and it really does 100% depend on what your contract says, and how delays are dealt with and who covers the responsibility for that. So if it says, if there's a clause in there in your agreement which says your responsibility for delays as a result of Brexit is entirely an obligation for the supplier, or a risk rather for the supplier, then that will be their risk. So it's important to have a look at your contract and see how it's dealt with. Dominic, I don't know if you have any thoughts on that.
Not much to add. I mean, I guess from a main contractor's point of view, if you don't have a Brexit clause, if your contract's silent on it, then the starting point is going to be that the contractor is responsible for procuring goods in time to comply with the programme. So it goes back to Jamie's point around the value of having those conversations about negotiating Brexit clauses. And I guess there was a time when employers were very reluctant to entertain those sorts of discussions. But as we see the difficulties playing out, and as we come out of a period of COVID where there's been a much greater extent of collaboration in the sector, there may be scope for a more open conversation about how you allocate those sorts of risks, given that they are real uncertainties. I think when people knew there was going to be a deal, the expectation was there would be frictionless trade, there would be no tariffs, so contractors should take the risk, but that doesn't seem to be the way things are playing out.
Yeah, I've certainly seen in the last couple of months that the clauses have been developed more sort of a collaborative approach, and let's see as they arise. But yeah, I totally agree with both Dominic and Jamie. It's always going back to the contract to see, but making sure that you get those clauses up front and consider all of the risks at the outset.
Okay, thank you. And finally, buying product from the UK, can the extra cost not be paid by the supplier? How do we find out how much extra will we be charged instead of a courier arriving looking to be paid? I guess a lot of people are having that same issue.
Yeah, again, I think this actually is very similar to the previous question, and to be honest with you, I know I'm aware of a number of companies that have chosen to absorb costs like that when they are supplying. It really does come down to once again the terms of the contract, and you know what it says specifically around charges. If it goes back again to what Dominic said, if you're a contractor, you know, you're the one that's going to be carrying those costs. If you're the main contractor on site in Ireland and you're bringing these, you're bringing materials into Ireland, you're ordering them in, you're going to be responsible for that extra cost. So it is about negotiating these Brexit clauses into the contracts to try and deal with these specific issues.
Okay, well, we have gone over time. I'd just like to say to everyone, if you have any further questions for Lisa, Dominic, Jamie or myself, please do contact us directly. But before I sign off, I'd like to thank my colleague Luke, who has been working off screen to make this webinar happen. And I'd also like to say a massive thank you to Lisa, Jamie and Dominic, and also thank you for attending today. Many thanks.
Thanks, everybody.
Thanks, everyone. Bye.